Well, thank you, Charles, and let us welcome you to our Abuja Center this Monday morning. A bright morning here in the federal capital. As always, my name is Mwabueze Njoko. Now, you must have heard that the Central Bank of Nigeria is considering the conditions for opening accounts for Nigeria's local governments. You know that on June 11, 2024, the Supreme Court gave what was regarded as a landmark judgment that every one of us thought was going to instantly create financial autonomy for local governments. And the second condition that the Supreme Court gave, or rather the conditions the Supreme Court gave, were that one, the local government should be democratically elected. No committees, no sole administrators. And that monies from the federation account should now be paid directly into local government accounts and not through the state governments. In fact, the Supreme Court said it was unconstitutional to do so. But just 2 weeks ago, the Federal Accounts Allocation Committee, we call it FAC, distributed funds for December Federation earnings. And as before, the checks for the local governments were handed to the Commissioner of Finance for the states. And let me remind you that on January 1, when some governors went to visit the president in his Ikoyi residence, the president made a political remark. He said that he was not taking control of the local government from the state governments. They were still in charge, he said. So, are we going to get that financial autonomy? I have my guest in the studio this morning, but before I introduce him, let us take this short report. Stay with us.
Justice Emmanuel Agim, leading 6 other justices of the Supreme Court, on June 11, 2024, delivered a judgment which was considered to be a milestone in Nigeria's constitutional democracy. The justices had declared that it is unconstitutional to withhold funds allocated to local governments, dissolve local government councils, or appoint caretaker committees. The court also ruled that monies meant for the local government from the federation account should be paid directly to the account of the local councils. The December 2024 federation account allocations shared on January 16, 2025 for the local governments were however paid to the state governments, making the financial autonomy which the Supreme Court ruled an illusion.
To contravene the Supreme Court order, that is where the Attorney General, who is the Chief Law Officer, should come. If you feel that the judgment of the Supreme Court is ambiguous, is not approach the Supreme Court for clarification. The law is straightforward. You have no right whatsoever to direct how local government funds should be shared or used. Local government chairman is there with his councillors. State governor is there with the State House of Assembly to administer the money meant for the state. This one, okay, if you are now saying, would the National Assembly and the President control the money coming for your state? It doesn't work like that. So that is just it. If you feel that the local government chairman and the councillors are misusing the fund, you approach EFCC, you approach ICPC, you approach the police. They are not under immunity. They should be investigated. Where they feel that there is a corruption, they looted the money, they should be made to face the wrath of the law.
The state government seems to have acted within their legal rights as prescribed by the Constitution. Section 162, subsection 5 of the Constitution prescribes that the amount standing to the credit of the local government councils in the federation account shall be allocated to the states for the benefit of the local government councils. A direct payment to the account of the local government as declared by the Supreme Court would have contradicted this provision of the Constitution. Section 162, subsection 6 of the Constitution creates more challenge in the ruling of the Supreme Court. It provides that each state shall maintain a special account to be called State Joint Local Government Account, into which shall be paid all allocations to the local government councils of the states from the Federation account or from the government of the states. When some state governors visited President Bola Ahmed Tinubu on January 1, 2025, the president said that he had no intention to take away state control of the local government away from the governors.
You have the control of your local governments. Do what you expected of grassroots effectiveness and restoration of their hope. It's in your hand. There's nothing, no one is among us on all these tiers of government. There was some gossip that maybe we had a disagreement or quarrel and everything when it was local government's autonomy. No. Just drive the development down there to the local government authorities. Nobody wants to take the control away from you. But collaboration, let's do it together and make sure Nigeria is better off from it.
So, but you have a president that is saying, "Oh, I'm not taking anything away from you." What for? Eh? So, which means you have already, bring yourself back. You've given, they have won. That no, I'm not taking anything away from you. You should take away something from them, please, for God's sake. The president should take something away from them and damn the consequences. And the fact of the matter is that if the president is bold enough, and then come out very strongly to fight on the side of the people, what he doesn't know is that, believe you me, the people may revolt against the other people, the governors. More so, like I said, this is a situation where you have the judiciary on your side, you have the National Assembly on your side. So what again are you looking for? You installed the principal officers of the National Assembly. You appointed the Chief Justice of the Federation. You appointed the INEC and everything. So you have the police. Why are you afraid of these local champions?
That thing is a political statement. Whatever the president said cannot set aside the Supreme Court judgment. When someone said, I said, Mr. President, I am not taking away your supervisory role in the state. They said the president have a supervisory role in the state. Don't you fear? He controls the DSSS in the state. He's the commander-in-chief. He controls the DSSS. He controls the DSSS, the police in the state. But would that amount to the president controlling the funds of the state? The answer is no.
In effect, politically and constitutionally, the state government still have a firm control of local government in the country.
There's no way you can have elections conducted by the governors themselves. They appoint the electoral officers. They appoint the tribunal if at all there's any issue or something like that. So I don't know what kind of magic you want to perform that these governors will not continue to have that grip, on the tier, that tier of governance. And so that's why even when some of them attempted to have what they want to call elected officials, we saw what happened. Nothing changed from what they have been doing. It's like it's a question of appointment. It's like local government has been reduced to a department, under the governor's office. So that he now appoints who he wants.
the councillors, the chairman, and what have you. He appoints them. They will now be returned, that one party has won everything that is put up for elections, as if people in that area are on robots or something like that. So has it really worked? If we have to be sincere with ourselves, it has not worked. I have not seen the impact of the reforms or of the judgments of the Supreme Court.
Unless the National Assembly takes steps to amend the Constitution, the financial autonomy expected from the June 11, 2024 judgment declared by the Supreme Court will remain an issue that rakes up political dust in Nigeria. In Abuja, Nasiru Usman for Signature TV.
Thank you. I know that report has laid the ground for this conversation this morning, and I said we can now meet our guest, Joseph Silas Ono. Imagine that, or Joseph Ono Silas. Joseph, a Hebrew name; Silas, a Hebrew name; Ono. Barrister Ono, you are welcome to the program.
Thank you, Chief Mwabeze.
Are you Hebrew?
Well, I'm from a place called Uburu, so you can also call it
Uburu and Hebrew.
Yes.
I understand.
So we're also part of the sons of Jacob.
Thank you. You are welcome.
Thank you.
You've heard my introduction.
Yes, I did.
The Supreme Court gave a judgment on July 11, 2024, by which judgment many of us believed that the local governments were going to get financial autonomy. But just 2 weeks ago or thereabouts, the Federal Accounts Allocation Committee distributed funds for December and still handed the checks for local government to the state commissioners. Does that not contradict that Supreme Court judgment?
Well, that action is actually a breach of the Constitution as it stands today, because from the day the Supreme Court handed down that judgment, the Constitution, as it is now, is that the local governments have financial autonomy. And the autonomy is not just in words, it should also be in deed. That is to say that the 774 local governments in Nigeria ought to individually maintain an account with the Central Bank of Nigeria, wherein their monthly allocation will be paid directly to them. And they can account for it whenever they are required to. They have no business resorting to any appointee of a state governor for their own funds. As it is, if monies are given to the commissioners of finance in the state, it is the same thing as giving that money to the governor, because the commissioner serves at the pleasure of the governor. The commissioner cannot dispense with state funds without the approval of the governor. So the fact is, in fact, in breach of the Constitution. So I think they need to rethink their steps and action and encourage the local governments to quickly open accounts with the Central Bank of Nigeria. Maybe they were handicapped by the fact that these local governments have no accounts with the CBN wherein they will make these payments. But for me, that is not an excuse. Immediately that judgment was handed down, that ought to be done without delay. They ought to reach out to these local governments and say, pay in your funds. Send your accounts where funds will be paid into for you. But that hasn't happened. And perhaps they are observing the Constitution in breach.
Let me draw attention to what I need education on. Section 162, subsections 5 and 6 are clear on which account the federal allocation to local government should be made. Section 5 says it should be paid to the state governments for for the use of local governments. The second subsection 6 says the state governments and local governments should open a joint account into which such monies should also be paid, and monies from the state government should also be paid for the local government to use. Let me ask, with the judgment of the Supreme Court, has that pronouncement, has that provision by the Constitution become of no consequence?
That judgment is now the provision of the Constitution, which is that there is nothing like joint allocation accounts anymore. It does not exist in fact and in law. Whatever is written in the papers of the Constitution, the letters, no longer applies. It is that decision, the interpretation given by the Supreme Court that applies. And I agree with the position of the Supreme Court because we cannot claim to be a federation and then be operating a unitary system. If we are a federation, federating units ought to be independent financially from the other units of government. So you cannot have the local government, which is a third tier, dependent on the state. As it were, the states are not dependent on the federation. They are entitled to what is theirs and they get it. So, and they generate and contribute to the federation. So the local governments too ought to generate, keep percentage, contribute to the center, not to the states anymore. They will now be contributing to the center since they are generating and drawing directly from the center. So those revenue calculations will have to be tinkered with. So forget about Jack. That was specifically what the Supreme Court targeted and ruled against, because the state governors were using them, that is a joint allocation account, to perpetually keep these local governments under their checks, or should I use the word under their whims. So they do what they like, they get this money, spend them, and get the local government chairman to sign them off. But I'm sure we will begin to see more independence by the time these chairmen draw their allocations directly from the federation account. That should also apply to the legislative arms of government. When they have their own financial independence, without any interference, we'll begin to see a day where the State House of Assembly will have the guts to question governors and call them to order, and maybe begin to impeach badly behaved governors. But for now, we have just two levels of government, the federal and state, and we have just one arm of government, the executive. The rest are subservient because of finance.
Let me draw attention to another provision of the Constitution that tends to create some contention in the ruling of the Supreme Court as is applied to local governments. The Constitution also provides that the state legislatures will make laws for the good governance of the local governments. In other words, the state legislature has a responsibility to create laws to effectively run the local governments. And when they create laws that undermine financial autonomy, they're acting within the Constitution. How do you manage it?
Now, because the Constitution has already provided for financial autonomy, the State House of Assembly have no powers to amend the Constitution.
But they make laws for the running of...
Making the laws will be in conformity with the Constitution. The law must be in conformity with the Constitution. You cannot make a law on what the Constitution has already covered. So for the smooth administration, you can now make laws on how the finance of the local government are to be used, right? The funds, how to use them, yes. How to manage the funds, how to have checks and balances. Now remember, the local government also have their own legislative arms, the councillors. So we tend to forget them in all of these things. Although laws made by council are bylaws, they do not have the same force as laws made by the state legislatures. So that is why you have the state legislatures making these laws for the local government so that they are enforceable. But they cannot make the laws without input from local governments and especially the councillors. So they ought to work together to know the challenges of the local government and make laws that will allow for smooth operation, not amending the constitution to now say, yes, constitution say you can have your account, but we are now saying you cannot. No, you can't do anything contrary to the constitution.
Yeah, but just say something now. They can make laws on how they can effectively and usefully apply those funds.
Yes.
Including saying, for instance, hand over this money to state government.
No, if a local government, even as we have it today, but they are receiving their fund directly from the federation. If a state governor has a way that he devised them, devised for them to hand over their fund to the state government,
in the law.
It's possible. Is it not your money that you're handing over to the state government? But you will account for it. No longer will a state governor be held responsible for mismanaging local government funds. So any local government chairman who carries his local government money and gives to the state government will account for the money. Nobody will hold the governor responsible for it because the governor is not in charge of that fund anymore. So if you take your money and donate to the state government, you have lost out. State government will happily accept it and use it as state funds without even necessarily doing anything for your local government. They can use it to pay their staff salary, or the governor will use it to do his foreign travels, whatever he deems fit. So the local governments now, there are laws that the House of Assembly can make regarding finance is that they can also have their budgets, which must be approved by the councillors. You get that kind of point. So once House of Assembly makes such laws to say a local government chairman cannot expend monies without approvals by a certain kind of committee in the local government and without the budget having been approved by the councillors of that local government. So in a way, the local government will now be presenting budget to the councillors for approval. And then they will look at the projects the local government chairman has proposed. And councillors may now say, you've not captured anything in my ward. There is no project in my ward. Or these are the priorities in my ward. So you capture projects and other activities that you design for the year, for the financial year, and present to the council in your local government. And then they approve it. If the state legislature make that a law, it's enforceable and it's binding. But the councillors, even if they do it, it's just a bylaw that may or may not have so much force as the law made by a state. Because the state can actually also prescribe severe punishment for breach. But the councillors have limits to what they can prescribe as punishment for breach.
Let me digress a little bit.
Yes.
Into the politics of this local government. As you heard in my introduction, on January 1, when some governors visited the president in Ikoyi, he made a political statement, not a legal pronouncement.
Yes.
He said that he was not taking away the control of local governments from the governors, that they were still in charge. What did that tell you?
Well, the president, first and foremost, is a politician. And I do not think that it was him who pronounced on the independence of the local government. It wasn't the president, it was the Supreme Court, which has the power to do what they did. Even though the federal government is a party, the Supreme Court could have ruled against them. But they agreed with the federal government and gave that judgment. So I do not see that as the president attempting to take away anybody's powers. He has just made an application that he believes in about true federalism. This is one step. He has always been a man that has been talking of true federalism in the Afenifere platform. So perhaps we'll begin to see more of that movement. We've seen the tax reform proposal, which for me works well within the Federation. We're seeing this one now, which is a way of creating a truly independent third tier of government. We hope too that revenue generation and contribution and also derivation will also all change, so that we do not have a federation where the other tiers of government go hand in cap to the federation to collect money. It would be better if generation and derivation are properly delineated and defined, so that the local government and state generate and they tell us what they have generated, and state and local government both contribute certain percentage to the center of what they generate. So it will now be the federation getting from state and local government. Instead of states and local government collecting from the federation, it now looks like the federation that doesn't produce anything is giving
to those who
produce. And that is why our economy keeps suffering. We'll remain a petroleum dependent nation. If we generate and the derivation is bottom up, it will boost our economy, because local governments will go to their to the sector where they have comparative advantages and develop themselves in order. The federal government can now begin to tax local governments and to tax states, and state will tax local government. That we must increase our revenue share so that we will do better in the coming year. When you know that you're not going to get anything from the federation,
if you don't contribute,
you work harder. That is basically saying resource control, which is where we ought to be by now. So I look forward to seeing the president bring up the issue of this resource control, so that every state will develop what they have and contribute to the center. I do not know why some states are afraid of this. I have recently ventured into farming, and I can tell you there is more money in farming than petroleum that we're fighting over. Farming is a lovely business, and every part of this nation has an advantage in one form of farming or the other. We just need to look inward and take a leap of faith. Reduce our concentration on these petroleum resources and the gold that is causing all the bloodshed across the country.
Let us look at another pronouncement by the Supreme Court. The Supreme Court stated clearly that the Constitution provides that local governments must be run by democratically elected officers.
Yes.
And then it made it clear that this money should be given to local government that are democratically elected.
Yes.
But there's something that everybody has observed.
Yes.
The state governments, in obeying this Supreme Court pronouncement, quickly rushed to conduct local government elections. But every other commentator on this country says there were no elections. They just rushed, a laughable process. Some of them sat in their bedrooms with their uncles, wrote down names of chairmen and councillors, and gave those names to the state electoral commissions, and they just announced. How do you react to that?
Now, this is not a new thing in Nigeria, the fact that we do not have elections. It's not a new thing. It's not just at the local government levels. At state and federal level, we do not have elections. So I bring this blame squarely before the judiciary. It is the fault of the judiciary that our democracy is quickly collapsing. We cannot have any election today in Nigeria that people have no complaint over, from presidential to councillorship. And it is because people are allowed to get away with impunity. So governors hitherto will appoint sole administrators or caretaker committees in local governments. And then you wonder, how many times have a president appointed caretaker governor for
Governor
states
or sole
or
administrator
sole
of a
administrator
state.
for a state? If that is their presumption that they are bigger than the local government, the federation is bigger than state. So the presidents cannot do that. Likewise, the governors, they cannot also appoint local government chairmen. These are constitutionally provided offices. And the only way the Constitution provides for filling up our political offices, which are elective, is by election. Local government chairmanship is not an appointive position. So if it is by election, the election must conform with all the standard of electoral processes. But we have state electoral committees, which are more like a department in the governor's office. They conduct the worst form of elections. It is the only election where a particular political party loyal to a governor wins 100%, right? Results are announced even before the election begins in some cases. So until we agree as a people that our electoral system need a quick fix and the judiciary need to also be sincere and honest, we would not be making any progress.
You know why I ask you this question?
No.
We're talking about financial autonomy, independence of the local governments. Does this pseudo process of conducting elections, which are not real process of conducting elections, and that produces the handmaids of the governors as chairman of local government and councillors, does it not really undermine the intent of the Supreme Court pronouncement to give autonomy, real financial autonomy to the local governments?
Well, the intention now have been achieved. Is that the local government can now have an account to draw their money directly from the federation. It remains for the implementation, but for the fact that now went to give the same allocation to state government.
Yeah, because in any case, the local government don't have accounts with the central bank.
That will be done, I'm sure. With all of these probings that are going on, the local governments will eventually have their accounts and they can draw directly from the federation account. On the part of the election, the law can always be manipulated. They said a democratically elected executive in the local government. Whether an election was done properly or not is a different question, which the judiciary also ought to uphold, right? So if they are trying to conform in order to draw the money without adherence to processes and procedures, they can do that, after which anyone who feels the process and procedure were not followed can challenge them in court. And the court can say, what you did was wrong. Remove that one and bring another. But which court now has jurisdiction over local government elections is the state high court. Most state high courts are also in the pocket of the state governor. So where do you go to?
I should ask that question.
So at the end of the day, we're still running around in circles because they will do a window dress election, still put the people they would have just simply appointed to go to these local governments and draw this money from federation account, and the governor will still be telling them how to use the money. So you'll find that local governments don't present budgets anywhere. Like we said, the State House of Assembly can make laws that they should present budget and the projects they intend to carry out. Even when they do that, the governor can say, bring your budget for me to approve first before you go and present it. Let me see the things you want to do. It is the projects I want in the local government that will be done. So because the local government is the most powerful tier of government, that is where the votes are. So governors don't want to give up that control. If local government chairmen become truly independent, No president will be talking to governors if he wants election. He will go straight to the 774 and talk to them. So you don't want to give out or give up that control. So the governors don't want to be shut out. In America today, where these things are truly practiced, you see how powerful mayors are. They come to our countries and are given almost presidential honors because in their country, they are independent
And they are in charge.
Even the president cannot tell them what to do within the scope of their responsibility. They will disagree with the president and do what they think is best for them. And the fund they are entitled to, they get them. When our strong president that we supported, Donald Trump, decide to freeze some funding to some cities, they are in court challenging it now that no, you can't stop those fundings. They must come to us. And they generate. They also keep part of what they generate. They contribute to the center and to the state. So we must begin to work towards that direction. Development cannot be from the top to bottom.
Development cannot be from the top to bottom, should be from bottom to up. We take a break, and next we look at the responsibility of the legislature in upholding the independence of the local government. And as she alluded, as we spoke, also the responsibility of the judiciary. That will be when we come back. Please stay with us.
Justice Emmanuel Agim, leading 6 other justices of the Supreme Court, on June 11, 2024, delivered a judgment which was considered to be a milestone in Nigeria's constitutional democracy. The justices had declared that it is unconstitutional to withhold funds allocated to local governments, dissolve local government councils, or appoint caretaker committees. The court also ruled that monies meant for the local government from the federation account should be paid directly to the account of the local councils. The December 2024 federation account allocations shared on January 16, 2025 for the local governments were however paid to the state government, making the financial autonomy which the Supreme Court ruled an illusion.
To contravene the Supreme Court order, that is where the Attorney General, who is the Chief Law Officer, should come. If you feel that the judgment of the Supreme Court is ambiguous, is not approach the Supreme Court for clarification. The law is straightforward. You have no right whatsoever to direct how local government funds should be shared or used. Local government chairman is there with his councillors. State governor is there with the State House of Assembly to administer the money meant for the state. This one, okay, if you are now saying, would the National Assembly and the President control the money coming for your state? It doesn't work like that. So that is just it. If you feel that the local government chairman and the councillors are misusing the fund, you approach EFCC, you approach ICPC, you approach the police. They are not under immunity. They should be investigated. Where they feel that there is a corruption, they looted the money, they should be made to face the wrath of the law.
The state government seems to have acted within their legal rights as prescribed by the Constitution. Section 162, subsection 5 of the Constitution prescribes that the amount standing to the credit of the local government councils in the federation account shall be allocated to the states for the benefit of the local government councils. A direct payment to the account of the local government as declared by the Supreme Court would have contradicted this provision of the Constitution. Section 162, subsection 6 of the Constitution creates more challenge in the ruling of the Supreme Court. It provides that each state shall maintain a special account to be called State Joint Local Government Account, into which shall be paid all allocations to the local government councils of the states from the federation account or from the government of the states. When some state governors visited President Bola Ahmed Tinubu on January 1st, 2025, the president said that he had no intention to take away state control of the local government away from the governors.
You have the control of your local governments. Do what you expected of grassroots effectiveness and restoration of their hope. It's in your hand. There's nothing, no one is among us on all these tiers of government. There was some gossip that maybe we had a disagreement or quarrel and everything when it was local government's autonomy. No. Just drive the development down there to the local government authorities. Nobody wants to take the control away from you. But collaboration, let's do it together and make sure Nigeria is better off from it.
So, but you have a president that is saying, "Oh, I'm not taking anything away from you." What for? Eh? So, which means you have already, bring yourself back. You've given, they have won. That no, I'm not taking anything away from you. You should take away something from them, please, for God's sake. The president should take something away from them and damn the consequences. And the fact of the matter is that if the president is bold enough, and then come out very strongly to fight on the side of the people, what he doesn't know is that, believe you me, the people may revolt against the other people, the governors. More so, like I said, this is a situation where you have the judiciary on your side, you have the National Assembly on your side. So what again are you looking for? You installed the principal officers of the National Assembly. You appointed the Chief Justice of the Federation. You appointed the INEC mind, everything. So you have the police. Why are you afraid of these local champions?
That thing is a political statement. Whatever the president said cannot set aside the Supreme Court judgment. When someone said, I said, Mr. President, I am not taking away your supervisory role in the state. They said the president have a supervisory role in the state. Don't you fear? He controls the DSSS in the state. He's the commander-in-chief. He controls the DSSS. He controls the DSSS, the police in the state. But would that amount to the president controlling the funds of the state? The answer is no.
In effect, politically and constitutionally, the state government still have a firm control of local government in the country.
There's no way you can have elections conducted by the governors themselves. They appoint the electoral officers. They appoint the tribunal if at all there's any issue or something like that. So I don't know what kind of magic you want to perform that these governors will not continue to have that grip, on the tier, that tier of governance. And so that's why even when some of them attempted to have what they want to call elected officials, we saw what happened. Nothing changed from what they have been doing. It's like it's a question of appointment. It's like local government has been reduced to a department, under the governor's office, so that he now appoints who he wants, the councillors, the chairman, and what have you. He appoints them. They will now be returned, that one party has won everything that is put up for elections, as if people in that area are all robots or something like that. So has it really worked? If we have to be sincere with ourselves, it has not worked. I have not seen the impact of the reforms or of the judgments of the Supreme Court.
Unless the National Assembly takes steps to amend the Constitution, the financial autonomy expected from the June 11, 2024 judgment declared by the Supreme Court will remain an issue that rakes up political dust in Nigeria. In Abuja, Nasiru Usman for Signature TV.
Well, let me welcome you back. We're still here in our Abuja studio. Our guest still remains Silas Ono Joseph, a lawyer. Maybe toward the end, I'll ask him whether he's also concerned about Nigerian politics. But for now, we are considering independence of the local governments as pronounced by the Supreme Court. Now, Ono, we are looking at the handicaps, the obstacles, the maneuverings that seem to be undermining the pronouncement of the Supreme Court. In this country, there used to be what was called judicial activism. When a court, not necessarily following the entire thing that were presented to it, says something extra those presentations, but thinks it is necessary to act on it to correct a matter. Where can judicial activism come into the whole of this to help uphold the pronouncement of the Supreme Court?
Well, the local government pronouncement by the Supreme Court in itself is the highest form of judicial activism, because the words and letters of the Constitution were clear. But the Supreme Court, believing that the words and letters of the Constitution were not in tandem with the spirit of true federalism, have altered the words and letters to bring it into conformity with what true federalism ought to be. So that is a good example of judicial activism. Now, it is not always good for the bench to be involved in lawmaking. It's dangerous most times. As it were, if you look at the electoral system, it is riddled by judicial legislation. So that is why there is so much confusion in election petition, because you have pronouncement of the Supreme Court that contradict itself at all points. If they say A, you will find another place they have said B, another place they have said C on the same issue. So it's inconsistent, because most time it depends on those who are seated in the panel and their own idiosyncrasy and their understanding of a particular issue. That is why it's important for the legislature to make laws. It is also important for the judiciary to give that law its ordinary interpretation, meaning and interpretation, so that you don't go convoluting a simple law to mean things that the legislature never intended. In our electoral system, we have a law that said clearly that when an election result is challenged and on the face of it, it appears that there was overvoting, you don't need to bring oral evidence, meaning you don't need to bring a witness to come and say, I saw it, I was there when once the results show that there's overvoting, it's conclusive. But the judiciary will tell you, no, you must still bring someone to come and speak. So you see, they are overruling the legislature, thereby undermining the institution of the parliamentarians. So every arm of government must be restricted to play their role as expected of them. Do not try to be a legislature because you are a judge. Do not try to be a judge because you are in the executive and now start interpreting the law the way it suits you. Do not try to be both executive and judiciary because you are the lawmaker and you feel you can reduce their power or increase it or do whatever you want with your lawmaking process. Everybody must play their role as expected of them. Anything short of this will mean we're wasting our time. We're not ready for a system. We're not ready for a society that works. We're not ready for a nation that people can participate in election, and when they lose, they will gladly accept the outcome because they trust the process and procedures. I was listening to former President Goodluck Jonathan speaking of his experience in South Africa or so. And he said in South Africa, he noticed that after election, it is strange for people to go to court after a result has been declared. But in Nigeria, it is strange for people not to go to court after election results have been declared. Reason still goes back to public confidence in the process and procedures.
And in the institutions.
In the institutions. If you conduct election properly and I lose, why will I go and extend my loss to the judiciary so that I will lose again? Right? I don't need to do that. I will accept it. But in Nigeria, people do what they want, knowing that even if you go to the judiciary, you will lose with all your evidence. Yes, with all your evidence that the election did not meet the minimum requirement of law, you will lose because the first language you hear will tell you electoral law is sui generis. And you go and check, what is this sui generis? It's the class of his own. What does it mean to be in a class of his own? Is it that laws don't apply in election, or the law of elections are different from other laws? They are laws. Laws are laws. You interpret them the way you interpret every other law. But once they tell you sui generis, just know they want to do injustice. Once you hear in any election case, the judges say election petition is sui generis, the next thing will be injustice.
Well, before we get to that injustice, let me also take on the legislature. You know that the Supreme Court pronouncement ought to be understood clearly. But in this conversation, I've raised certain provisions of the Constitution before the pronouncement of the Supreme Court. Those things are still there in those books, in that book. Does the legislature need to do anything to remove them now that the Supreme Court has made this very fundamental pronouncement?
Well, it doesn't have to be removed.
You see why I'm asking the question? Because you lawyers will be citing the Supreme Court has said, but for the ordinary person, the governor, he's still governed by that document.
You're reading that document, right? So now there will be reprints. You don't have to go and excise that portion from the... Yes. Like there are amendments to the Constitution that have been made in parts, and they will be referred to as certain alterations to the Constitution. It doesn't mean that now in the general body of the main Constitution itself, you now go and tear out that part. You know that that part has been altered. So you cannot be referring to the original content anymore. You now refer to the altered or the alteration or the altered version of that provision.
In other words, just in other words, because you still educate me better.
Yes.
In other words, in conversing on the Nigerian Constitution, I'll be right to say that the Constitution now provides that allocation to local governments from the federation account should go directly
to the local government.
Meaning that is the new
that is the Constitution, meaning that the local government ought to have their own federation, their own allocation accounts where this money will be sent to directly. And they should manage their funds independent of the states. That is the Constitution as we speak, unless it changes tomorrow. But for now, that is the Constitution.
Well, for now, that's the Constitution. As a matter of truth, this Monday, I was supposed to bring side by side the chairman of the Argonne Association of Local Governments, but he said he was out of town, so he couldn't join us. I'm sure that subsequently we'll also bring him in. Maybe there are other things he will tell us that Ono has not touched this morning. But for this Monday, I think I owe Ono a letter of thanks on your behalf for coming to our studio. Ono, thank you very much for coming.
Thank you, Chief.
You're welcome.
Thank you.
And from Abuja, I want to say good morning and have a great day.